Good day, ladies and gentlemen. This is Dr. Frel, your professor. Good morning, class. Today, our discussion is on the protection to labor in the Philippines. And the basis of our discussion is the Philippine Constitution and the Labor Code of the Philippines as amended. So what is the state policy on labor as provided in the Constitution? Section 18 provides that the state affirms labor as primary social economic force, that it shall protect the rights of workers and promote their welfare. And Article 13, Section 3 provides that the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. It's guaranteed the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities, including the right to strike in accordance with law. They shall be entitled to security of tenure, humane conditions of work, and a living wage. And they shall also participate in policy and decision-making processes affecting their rights and benefits as may be provided by law. When we say protection to labor, class, this is protecting the workers from dishonest union leaders and other forms of injustice or injustices against them. And humane condition of work means there is favorable conditions of work, including protection against abuse, harassment and violence, or having decent working condition, and many others. And speaking of living wage, this is a wage that is high enough for the employees to maintain a normal standard of living. The state also shall promote the principle of shared responsibility between workers and employers and the preferential use of voluntary modes in settling disputes, including conciliation, and shall enforce their mutual compliance therewith to foster industrial peace. And another is, the state shall regulate the relations between workers and employers, recognizing the right of labor to its just share in the fruits of production, and the right of enterprises to reasonable returns to investments and to expansion and growth. And now, class, under the Labor Code of the Philippines, particularly Article 3, it's on the declaration of its basic policy provides that the state shall afford protection to labor, promote full employment, ensure equal work opportunities regardless of sex, race, or creed, and regulate the relations between workers and employers. And again, the state shall assure the rights of workers to self-organization, collective bargaining, security of tenure, and just and humane conditions of work. Further, Article 4 provides that the construction in favor of labor, that all doubts in the implementation and interpretation of the provisions of the code, including its implementing rules and regulations, shall be resolved in favor of labor. When we say in favor of labor, class, this means labor contracts requires the resolution of doubts in favor of the laborer because of their imbued with social justice considerations. Now let's have the 3 facts about employment. First is, ignorance of the law isn't an excuse. This means person who is unaware of a law may not escape liability for violating the law merely by being unaware of its content. Second is that employment is a contract. But it's a contract so impressed with public interest that it must yield to the common good. When we say common good, this means it is for the benefit or the interest of all. The third fact is ownership of the enterprise makes the employment relations lopsided in favor of the employers. Now we have the three fundamentals of labor law. First is, its ultimate purpose is to place employment or employees at an equal footing with their employers. Speaking of equal footing, this means that the law of contract place employee on essentially an equal footing with the employer. Second is, it's all about minimum standards in basic requirements. And the third is, in case of doubt, it is to be interpreted in favor of the employees, as mentioned earlier under Article 4 of the Labor Code. Now we have the three basic rights of employees. First is the freedom from slavery as provided in the Constitution. This freedom prohibits people being held in conditions in which the powers attaching to the right of ownership is exercised. Second is enhanced by security of tenure. Security of tenure means employee cannot be dismissed unless for just cause or authorized cause. An employee cannot simply be terminated because the boss does not like the way he looks. Third is enhanced by due process. When we speak of due process in the context of employment, this is the right of an employee to be notified of the reason of his or her dismissal, and in case of just causes, to be provided the opportunity to defend himself or herself. Now we have the three basic rights of employers. First is ownership as provided in the Constitution as well as in the Civil Code. Ownership is taking the initiative to bring about positive results or by the owner of the business. Then the second is return of investment. We call it ROI, referring to the expansion and growth or fruits of the business. This is the ratio between the net income and investment. A high return of investment means the investment's gains compare favorably to its cost. And the third right is the right to use and abuse and or sell and dispose their products. Next is the three sources of labor law. One is, of course, the state, as provided in the Labor Code, in other statutes, rules and regulations, or jurisprudence. Second is the parties, such as that of the contracts, the company policies, collective bargaining agreements, the compromises, or quit claims. And the third is the principles of equity, or that of good faith, reasonableness, proportionality, non-diminution of benefits, and or unjust enrichment. Now class will talk about the conditions of employment. One of the conditions is the hours worked. This pertains to the period of time during which one engages in paid work. Article 83 of the Labor Code provides for the 8 hours work time. This is to safeguard the health and welfare of the laborers and to minimize unemployment by utilizing different shifts. So what are considered as hours work? These are all the time that employee required to be on duty and all the time that employee suffered or permitted to work. Employee stays in the workplace and wait for substitute. The workplace cannot be left as unmanned. It is compensable because he was forced by circumstances. However, meal time is not compensable. So what are the rules and regulations in determining work hours? One is, all hours are hours work which employee is required to give his employer, regardless of whether or not such hours are spent in productive labor or involve physical or mental exertion. Another is, all employees should not leave the workplace during working hours or else it will result to loafing. Third, if the work is necessary for employee or employer, he cannot abandon unless with the knowledge of immediate supervisor. And fourth, the time during which an employee is inactive by reason of interruptions in his work beyond his control shall be considered work time. Now the question class is waiting time considered as hours work? The answer is yes, but not all waiting time is compensable. Predominantly for the benefit of employers or those on call. They are required to be in place of work and is within the immediate call of the employer. So what is this waiting time? This is the time interval for which one has to wait after placing a request for an action or service and before the action or service occur. So waiting time spent by an employee shall be considered as working time if waiting is considered an integral part of his work or if the employee is required to engage or engaged by an employer to wait. Now, how about travel time? Is travel time compensable? So travel time is all the time spent traveling during regular business hours. So as to the question whether it is compensable, the answer depends on the nature of travel involved. Compensable time is the time spent in travel time or the working time if these are emergency call outside his regular work or working hours. Part of the principal activities or job of the employee, or they are required to report at a meeting place, to receive transactions, or to perform work there. Now, how about the provision of the law as regards to meals period? So this is not less than 60 minutes for the comfort and benefit of the employee. If he or she spent his time during this period, it shall be counted or worked until 4 in the afternoon. So we have the Anti-Red Tape Act that provides that there shall be no non-break, and this refers only to the processes or transaction of all government offices. Now you might ask class, can the meal period be shortened? The answer is yes. So this shortened meal period is to be included in computing hours worked and will fall with full pay. This is where the work is non-manual or not involve serious physical exertion. Second is where the establishment regularly operates not less than 16 hours a day. Third is where there is actual or impending emergencies. And fourth is where the work is necessary to prevent serious loss or of perishable goods. Now we'll have the kinds of employment under the labor code. We have regular employment, casual employment, probationary employment, project employment, seasonal employment, and fixed-term employment. So what is this regular employment? This is one where, notwithstanding any written or oral agreement between the employer and the employee to the contrary. First, the employee has been engaged to perform activities which are necessary and desirable in the usual business or trade of the employer. And the employee has rendered at least 1 year of service, whether such service is continuous or broken, with respect to the activity in which he is employed, and his employment shall continue while such activity exists. And the employee is allowed to work after a probationary period. So what is the test of regularity in this aspect? The test is the reasonable connection between the particular activity performed by the employee in relation to the usual business of the employer. How about in casual employment? This is where employee is engaged to perform activities which are not necessary or desirable in the usual trade or business of the employer. And work is merely incidental to the business of the employer, and such work or service is for a definite period made known to the employee at the time of the engagement. So remember, class, that a casual employee may become a regular employee after 1 year of service. Whether this 1 year of service is continuous or broken with respect to the activity in which his employment shall continue while such activity exists. The purpose of this class is to give meaning to the constitutional guarantees of security of tenure and the right to self-organization. Now, how about project employment? This is the employment of an employee that has been fixed for a specific project or undertaking, that the completion or termination of which has been determined at the time of the engagement of the employee. So, where the employment of project employees is extended long after the supposed project has been finished, the employees are removed from the scope of project employees and are considered as regular employees. Then we have seasonal employment. This is one where the work or service to be performed by the employee is seasonal in nature, and employment is for the duration of the season. A seasonal employee may become regular after 1 year of service. Once he attains such regularity, he is properly be called regular seasonal employee. But during off-season, the relationship of the employee and employer is not severed. The seasonal employee is merely considered on leave of absence without pay. So, remember, class, that seasonal workers who are repeatedly engaged from season to season performing the same task are deemed to have acquired regular employment. Now, how about temporary employment? This is where employee is engaged to work on a specific project or undertaking which is usually necessary or desirable in the usual business or trade of the employer, and with that, the completion of which has been determined at the time of the engagement of the employee. And if the employment of an employee is covered by a fixed contract of employment, so that employment that will last for a definite period as agreed by the parties. So what are the criteria for this? One is fixed period was knowingly and voluntarily agreed by the parties, and the parties dealt with each other on more or less equal terms. And last class is the probationary employment. This is one where the employee is on trial by employer, during which the employer determines the qualifications of the employee for regular employment. The general rule under this class is that the probationary period should not exceed 6 months, or which is being consist of 180 days. The standard should be made known to the employee at the start of the engagement. Otherwise, the employee is deemed a regular employee from day 1. So, if no stipulation or probationary period employment is deemed regular. And an employee who is allowed to work under probationary period is considered a regular employee. Okay, so that would be all class for this topic. And for your activity, create a 1-minute video depicting employment issues among teachers in the Philippines. And make sure to send your output in our Google Classroom. Again, this is your professor. Thank you for watching. See you in the next video.